qualified experts that the necessary structural repairs and changes have been completed properly. I have attached copies of that engineering
Man, that's
report.
not an issue. But the city staff and that's not an issue.
All right,
We're only moving with the request that we have from them.
it does apply to my reasons for objecting. I need proof that this is not still a danger as the,
Well, did you provide proof that it is a danger?
yes, please see attachment B. That is the
Excuse me.
engineering report.
Window?
So essentially, that would be part of our plan review, is to make sure that the structure is structurally integrity. So if there are issues as outlined and this thing, those would have to be addressed before we could ever give them a CO. So just because they might not be addressed now, doesn't mean that they won't be.
Mr. Bondera, would you want to come up with it?
I mean, there's it's hard to address all of this, but I can try to address what I did here. And again, the house or the building is in a AE 11 flood zone. We supplied the flood elevation certificate to staff. It's the base flood is AE 11. The finished floor is 80 or it's elevation 19.2. It's fully compliant with that in terms of where that finished floor would be. As far as the pool is a different question, Mark, and I can't really speak to that.
And I don't think that's relevant.
I'd like to, I don't know how to really address all of this, if this is going to be point by point, where I have to try to address some of the concerns the state is having. But there's some questions, I think, in her summary about whether the lower level is a private garage. And the statute or the language of that, and I think city staff agrees with that, that the detached garage is defined as a use. It's not defined as a structure, meaning that a garage is for motorized vehicles. It's not storage. And a garage has a separate use. Storage has a separate use as defined by the UDO, and I have a handout I can give you that comes right out of the UDO. This center has no intention of using that as a garage. The other, I think I'm trying to sort through some of these questions. I don't know if it's premature to do that,
I'm
but
wondering if I could perhaps finish my presentation and then perhaps you could.
He's got the
Please.
floor, excuse me, he's got the floor right now.
so again, the pools are not relevant. The flood zone, it complies. The center has a permit for some of the repair work that came out of that initial structural work. So that's on record. The center may come up to speak, but there's some language here that I want to address the garage question and why it's not a garage. The other question is, does it occupy 50% of the rear yard? The rear yard is defined by the ordinance is the dimensions in the rear property line to the setback requirement. The structure does not encroach at all into that dimension. So what I mean by that, there is no encroachment by this existing building into the required rear yard of the building. So I'm just kind of preempting that point, and so I guess I'll wait, but I might come back up.
Yeah, we'll let Ms. Davis continue.
Thank you. I believe we're still on page 2, second bullet point, regarding whether this accessory building meets the standards for a dwelling space. So is this structure appropriate for consideration as an accessory dwelling? Okay. UDO Article 3, Section A.2 states the total area of accessory structures, excluding swimming pools, shall not exceed 50% of the rear yard area of the lot and shall meet all rear and side yard setbacks of the district. So it looks to me like the rear yard area of the property is approximately 2,977 square feet. based on the survey drawings in the packet, which you have. 50% of 2,977 is 1,448 square feet. The total square feet of the structure, according to the information presented, is 778 square feet on each of the 2 floors, for a total of 1,556 square feet. And that is an excess of 108 square feet, which is roughly 7.5% larger than is allowed. Can this apparent discrepancy be explained? And would it be reasonable to allow such a large discrepancy? The existing accessory structure has 2 big garage doors opening up into the ground floor. They are not shown in the photos included in the application packet, but they're clearly shown on the building diagrams in the packet. And the definition in the UDO Article 8 states, the definition of garage: a building or space used as an accessory to or a part of the main building, permitted in any residential district that provides storage space for motor vehicles and in which no business, occupation, or service for profits is in any way conducted. It is a garage and a golf cart is kept in there. And that's a motor vehicle. It's a permitted vehicle. UDO Article 3, Section
Excuse me, 1 minute.
3.8. I'm sorry.
Can I ask, would it be appropriate to let you respond one at a time? What would be best? As she rolls at this,
We
you
say,
want to address each one, or you want to wait till the end?
I'm close to the end.
yeah, I'll wait until the end. That way she has her time. And
Okay.
Detached, Article 3, C.8. Detached garages with a second floor accessory residential dwelling, which is what this applicant is seeking to have, may not exceed ground level building footprint of 530 square feet. That's very clear in the UDO. The footprint of this structure, according to the information presented, is 778 square feet, which would be 248 square feet larger than the limit in the UDO. How is that discrepancy reconciled by the applicant or the city staff? It looks to me like the downstairs area is either a garage, although it's being labeled storage area, or it's part of the residential area. In other words, if it's not a garage, then how can it have an upstairs dwelling like this? If it is a garage, then how is this proposal for a 778 square foot accessory dwelling acceptable, since the UDO limits it to 530 square feet? Doesn't look like it can be neither or both of these things at the same time, does it? In the event that the structure is deemed not to be a garage, then I come to questions based on UDO Article 3, Section C, which states, point 1, an accessory dwelling may be within an attached or separate from this principal residential structure. Point 7, the accessory dwelling shall not exceed 800 square feet, which I believe is where some of this confusion seems to arise. The UDO does not envision a scenario in which an accessory dwelling unit is part of another building unless it is a main residential structure or a garage. In this case, the proposed accessory dwelling would be part of a garage. It appears to be far larger than the 530 square feet that the UDO allows, or the building in total. A standalone separate structure, which in this case is a total of 1,556 square feet, That's the upstairs and the downstairs. Almost twice the size allowed of the UDO. So can the applicant or staff explain how that works? You know, imagine you will attempt it. That's not the end of my remarks. But a question I know you will get to.
Ms. Davis, I think that it'll be appropriate for Mr. Van Dare to come up and address city staff, because I think a lot of what you're saying arguably requires you to have a certain type of expertise, textual, engineering, or otherwise, so that your conclusions to the effect that there are in fact discrepancies, and there are in fact total amounts of square footage which exceed the UDO.
Attorney Giuseppe, I have to raise an objection to your participating in this hearing because you represented the applicant as their attorney.
He is advising.
Right. As on this application, prior, as to how they should consider if at all information that's coming into place. Here, this particular hearing, this matter, new information on the new application at this time. So all I'm doing is just putting a characterization on what I see your space to be like.
I still object, especially since you have the city attorney present.
You object to this now.
I'm
So you want
objecting
to
to that attorney participating in
You're
this
sorry?
hearing. I am objecting to Attorney Ray Giuseppe participating in this hearing.
Your objection is noted. Thank you.
Thank you.
Would you continue, Ray?
That's all I wanted
Okay.
to put on the record.
You got it.
Again, this board can choose to not accept my advice on that.
Right.
About us, state what I'm thinking about it, and then we'll see what, the other information comes in, and it's up to the board to decide. Thank you.
If you were you asking, or were you stating that I should be presenting expert witnesses? I'm not an expert. I am presenting to you, I'm reciting definitions in the UDO and things that I personally know from living next door.
But you're also reaching conclusions.
I'm sorry.
You're also reaching conclusions about discrepancies, calculations, which I think require an expertise that you haven't demonstrated you have. That's my only point.
I believe that I have demonstrated it by pointing out what the square footage as presented in the application and what the UDO states the allowable square footages are.
I understand.
I don't have, I mean, what expert would I call to state what I've already stated, which is prima facie in the UDO and in the application?
I still think that what you're trying to conclude is not innocent for those purposes. That's my point. This is advice to us.
All right.
I'm here. Go ahead, Mr. Bowman.
I guess I'm just going to reiterate I'm not going to address much more some of the questions because it's difficult to grasp all of it. But again, the definition of a garage is a separate definition. I can circulate this on what that means and what storage. It's out right out of the UDO as far as the intent of that lower level space. It's considered storage. Ms. Stenner is here to, if you need her to confirm that it's going to be used as is proposed. And that section is based on use. It's not based on footprint. It's all used and it's not a garage. The other point is just that the rear yard, again, is measured from the rear setback line to the rear property line to the setback line. None of this building encroaches into that space. So there is no encroachment at all, the structure. There is no reduction of the rear yard. That section does not come into play in this application. That's, I guess, I don't have much to add.
Thank you. Ms. Wendell, do you have anything to add? In regard to this?
I have other issues, as you know.
We're
We're
gonna-
still
we're
on the
gonna get back to
garage.
you, man. We're gonna get back to you.
Okay.
please. If you've laid a lot of stuff out on us that we were not privy to prior to the meeting. So we have to rely on different people to help us interpret what you have presented. And so if you would allow us to do that,
Of
I
course.
appreciate it. Thank you.
One of the reasons I gave it to you, so you could have it in front of you.
Would have been nice to have it a week ago, but that's something we don't. But, you know,
I'll just reiterate that, we define garage and storage differently, as Mr. Bandera said. And this, and this structure is not a garage, Ms. Davis even mentioned, the driveway is 7 feet. To get a car there would be really reckless, so it couldn't be operated as a garage. Now, maybe they've stored a golf cart there before. I wouldn't call that a garage per se. I don't know. That's something I haven't dissected or split that hair. And if it is an issue, I'm sure that the applicant would be more than willing to no longer store their golf cart there. But that goes back to the point of saying that, no, we're looking at the structure, not in cubic feet, but in square feet. And the structure, the ADU itself is, yes, it's greater than 530 square feet. However, that provision is only meant for detached garages or attached garages. And I can address any other points.
we'll let Ms. Davis.
If a motor vehicle that is permitted, has a license plate and everything, it is in there and it is kept in there. How does that not make this a garage?
Is that a recreational vehicle?
The UDO is very clear.
It's not.
Motor vehicle, not, it doesn't go into different categories of vehicle.
So it was a tractor trailer, like a John Deere tractor, that make it a garage.
The UDO says motor vehicles.
Is there a definition of motor vehicle in the UDO?
I believe Director Meehan's trying to check it.
Mr. Bandera would like to comment.
I think, just to, and maybe Ms. Stenner might be willing, but, it's clear that the applicant is not intending to use it for a motor vehicle. That's the proposal. And she's sent an email to city staff stating that. And if she needs to come up and testify at that point, I think she'd be able to. The last thing I'd like to say is that Kylie Barefoot has been doing inspections on this property to deal with the structural report that's been ongoing, that the report from several years back. So
Thank you.
Hoping I'm done with the logics here. Top of page 4. The top of page 4, that first bullet item. The UDO Article 5, Section H states, when accessory structures, and it in parentheses says sheds, detached garages, etc., are to be placed within a special flood hazard area, the following criteria shall be met. Accessory structures shall not be used for human habitation, including working, sleeping, living, cooking, or restroom areas. UDO Article 5, Section H states, special flood hazard areas means the land in the floodplain is subject to a 1% or greater chance of being flooded in any given year. This structure is in the flood zone AE, that's EL10, a special flood hazard area according to the USGS 2025 firm map. Attachment C provides that for you. It looks like this in your packet. Did anybody else need to see the reference? I sure do wish I had slides for you. I know y'all know how to read something like this. Everything below the brown zone is AE, and it is AE elevation 10 or above. The red circle or teardrop, that is this property. And you can see there's the front area and then toward the back, and the special flood zone area is in the, or the structure in the back that is the subject of this application is in the AE flood zone, which is a special flood zone area. And so the UDO speaks very clearly on that. I don't need to repeat that for you.
Can I have Mr. Staff respond to that, please?
Yeah, so all due respect, this section 5H1 is taken out of context. Accessory structures can't be used as a dwelling space or none, particularly in a flood hazard area. However, by being granted a special use permit to allow for an accessory dwelling unit to be there, now the onus is on the property owner to bring that structure up to contemporary floodplain standards, which it is. I've done the staff review of the elevation certificate. It is at, as Mr. Bandera said, it's in the 11-foot base flood elevation. And I want to say the second story where the dwelling would be at is 19 feet. So it's, and then on top of that, it's part of our plan review would be to evaluate the structure for floodplain standards, make sure that there's no static discharge being able to get out and all that stuff. So
Based on the plan that's been submitted and the information you
well,
have.
that'd be part of the plan review. Not based off of this right here, because that's not part of the equation for an accessory dwelling unit per se. But we've already done our due diligence there and evaluated the situation. It is up to contemporary floodplain standards.
So it is, yeah, okay, so that meets the standard, and you will address the other issues as it goes to the
Correct.
plan review.
Yes, sir. But that's just to reiterate, yeah, no one's allowed to live in a shed, period.
Right.
But particularly making a shed habitable in a special flood hazard area is unwise.
I did include as attachment D, the elevation certificate. I think common sense dictates that although the second floor of this structure may be high enough to be out of the flood zone, a bad flood that affects the first level is going to destroy the upper
I'm
level.
sorry, Ms. Davis, that's irrelevant
Okay,
right here, just according to what it's HUDO, your personal opinion,
yes. Okay.
not really.
Regarding whether the special use would adversely affect adjoining property, including mine, I'd like to specify that by my best estimate, the building, the existing building, is within 100 feet of the interior living space of 11 separate private homes, including the main house on the property. 512 Brunswick Street, it's 45 feet away. 516 Brunswick Street is 99 feet away. But 509 West Street, right behind it, is 43 feet. Remember, I'm talking about the interior space of these buildings. 507 West Street, 67 feet. 505 West Street, 27
Can I excuse me, Ms. Davis, what is the relevance of this to what we're discussing? To engage, I'm having trouble with that.
Okay, this is a very tight neighborhood, even by Southport standards. And if you conclude that any adverse effect could come from this proposed use, please consider the question of whether it could negatively affect the owners, residents, and others in such close proximity who desire safety, security, and quiet enjoyment of their properties. And finally, regarding whether the proposed use will be in harmony with the area. I have no explicit questions about this other than asking you to consider these observations. To my knowledge, there's no other R10 zone property on the block bordered by Brunswick, West, and Short Street that has an accessory dwelling unit.
Again, relevance. I'm having trouble. You know, it's,
We're talking about in harmony with the area. And the harmony of the area is
but
this is quite
that's a
different from
personal,
anything else.
that's a personal opinion. That's not,
I gotta go up.
uh,
Good. Are you ready? The main structure at 508 West Brunswick Street has a heated square footage of 3,596 square feet, according to its 2018 multiple listing service report, which shows the main house is having 5 bedrooms and 4 bathrooms. This is already a very large residence.
yes, we,
Okay,
again, so that's,
well,
I appreciate where you're heading with it, and I've heard you. And I understand how dear it is to you, when you made that.
okay. Well, I mean, if I may conclude, you know, I hope I made it clear that I'm not here to tell you what you should decide. I'm letting you know what I hope you will decide, but I hope you will get answers to the questions I've asked before you make a decision. And that's all.
What question, I'm not aware of any question that hadn't been answered by staff or here. And unless you had some expert testimony or other information that we haven't seen. Or, I mean, I feel comfortable, just other members of the board feel comfortable with what we've heard. Any issues with what she brought up or with questions of Wendell? Okay. Wendell, you have anything to add?
No, but I'd be more than happy to stick around and answer any further questions.
We do appreciate that.
Yeah. The bug in the alignment here is the square footage of the structure. And I see it's ultimately, do you guys define this as a garage or do you define it as a storage unit? Staff, I've spoken with Director Meehan about this when the obstacle came my way. And we both came to the conclusion that it's a storage unit. And then we got confirmation from the property owner as such.
Well,
That's why we don't concern ourselves with item 8, limiting it to that 530 square foot.
and depending where we go with how the vote goes,
Yeah, I'm just saying
it
that's
could be,
the
it
only
could be a condition.
ointment that I can
Right.
think of, or bug alignment that I can think of as a negative issue.
I got
I do believe the property owner did want to say
Yeah.
something.
Ma'am, please.
To speak.
If you feel the need to, but
I'll be brief.
yes, ma'am, come up, step up. please.
I'm sorry.
Your name?
Jennifer Stenner, 508 West Brunswick. And
Sure, the truth, whole truth, and nothing but the truth, so you got it. Thank you, ma'am.
we can't help that our lots are small. All the structural things were completed and verified and permitted. Continue to go on that if there's anything new that arises. I talked to the builder and he said for the inconvenience, the structure is already there. The exterior is already done. There's not painters going on the outside. All it is interior work, which he said he could do in about 3 months.
Will this be used as a garage? Question? Yes.
Tell me about your golf cart that's in there. Is it licensed?
Is the golf cart in there?
Is it
Yeah.
licensed?
It is licensed,
State,
yes.
then it is a bid.
So I think it could be outside if that's a requirement. I thought it was safer when I leave because it's not my time. Else, anybody?
May I add something? If the board chooses to, grant this application, would there be a condition that the dwelling could not be rented separately from the main?
I can say it already was in the last 4 years ago. when I read it. It's not.
Existing, it's an ordinance prohibited. Right. And we have a standard add-on to our accessory dwellings that we always had that cannot be rented, so.
And I agree that, the electric and the plumbing.
Across the-
That can be changed.
It's the same, those things.
Questions? Any more comments? Questions, staff, of staff, anybody, or? Yes, are there any more speakers? Yeah, are there any more speakers?
Yes.
This is about, sir. Sure. I thought you were all here from that. Me too. Name and address, please.
Okay, I'm Woodrow Wilson Jr., live at 502 West Brunswick Street, right next to the Reverend Lou Davis.
Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth. So
I do.
thank you, sir.
I will be as brief as I can be. I will not recover, go over any of the things that Reverend Lou Davis has gone over. I moved to 502 West Brunswick Street in 2003. August of 2003. This same structure, this same building was a topic of discussion then. There had been city stop work orders left and right on it. When Wayne Strickland was the building inspector, we went through all of that situation with him. It's been a debacle from day one. What I would encourage, and I thank you for the leeway to say this, make a decision. We don't care whether she puts what she wants to put in there or not. Just make the decision and let's be done with this thing. 25 years of fooling with this building is a little much. So having said that, thank you all for the opportunity.
Thank you for your comments, yeah. Anybody else?
Debbie Barnes, 425 West West Street.
You raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. So, yeah. Thank you, ma'am. Well,
I had signed up to speak, but you actually addressed it, but I just thought I'd bring it up again since I did sign up to say it, which is, I think if they are wanting to turn that into an accessory building and it adheres to the UDO and the R10 zoning, would break. The rental is one we wanted to make sure got addressed, and now you've addressed it. And so, thank you.
thank you, ma'am. Any more questions? Yeah, okay. So I can close this public hearing. And then discussion, any discussion or questions by staff, by board members?
May I stay here? I have trouble hearing back there.
Yeah, you're fine.
Okay.
Yeah.
I think it's a myth, but today it is used as a garage with the licensed golf cart, because that has been a big mistake. Lightweight bid, which would bring it back to a garage now. I do feel that it could be appropriate that the board say, okay, we need a qualification stating that vehicle will not be housed in the town garage.
I don't know how the vote's gonna go, but however it goes, we usually handle this at the end.
Proposing a condition that the golf.
We're not there yet. No, Rodney. Well, no, I mean, question, oh, yeah, go ahead.
Imagine if someone had a motorcycle and brings it in the front door in your house garage at that point.
Kendall?
Just a smelly house.
License beer.
So your house becomes a garage?
Yeah, yes. Tonight.
Rodney, what was your question about Harley earlier? I didn't mean to shut you down.
I would say garage. I'm sorry,
I would say-
I was asked, are you doing mechanical maintenance on a vehicle?
If you don't want to be
That's-
rained on.
When you think of it, like, at least when you think of a commercial garage, you think of car lifts and oil or you're thinking of, cars on display, things like that. So that, for my part, to that point, no, your house would not be a garage.
I think we have the right to tell someone what they can and can't put inside.
Well, it's still relevant. I mean, why, what, if it's a garage or storage, it's already built. I mean, a square footage is square footage. You're not gonna.
It's not already ADU though.
Yeah, but the building.
Let me, if I can interrupt, Article 8, page 15, the garage private, I think this is what Rich, a building or space defined as a building or space used as an accessory or to or a part of the main building permitted in any residential district that provides storage space for motor vehicles and in which no business occupation or service for profit is in any way conducted. So. In storage definition, a deposition of commodities or items for the purpose of future use or safekeeping. Those are our definitions. Depending on again how the vote goes, I think all these issues could be addressed. We'll see. Okay. Close the public hearing. Any more questions or comments? So where are my motions? Yeah. Do I have any motions in regard to this application? Motion one, the use of, well, I'm gonna do that. I have a motion.
I move that, the use will not materially endanger the public health, safety, or general welfare if located where proposed and developed according to the plan is submitted and approved. Finding of fact being that the living area of the ADU would be well above flood elevation level.
Got a second?
Second.
All in favor signify by saying aye.
Aye.
All opposed, same sign. For the public here, I don't vote unless it's a tie. So you know why I'm not voting. That motion carried. Motion two.
Motion to use meets all required conditions and specifications.
We'll have a second.
We need finding of fact. It literally complies with.
It complies with UDO.
And it's fully compliant with what applies. Just got to say. Thank you.
We'll have a second for the second.
Yeah.
All in favor, say
Can you have a discussion? After the second, do this report, right?
Yeah.
I'm gonna bring that one back up, and I think we can handle it through qualification, but I think it's a fact that the vehicle that's there is a motorized vehicle, which our UDO says would then make it a garage. To your discussion, we're not here to say the UDOs needs to be changed or reworded, but it is as it is for us to deal with now. And that was consideration for your vote. This one.
The definition that you read. Is that from the UDO?
Yes.
So
Okay, we had a motion and a second. Some discussion. And final. All in favor of this motion signify by saying aye.
Aye.
Opposed, same sign.
Okay,
Okay, motion carries. Motion carries.
Okay. The use will not adversely affect the use where any physical attribute is joining or abutting property that for that use is a public necessity, finding fact the buildings there, certain, it's changing from the exterior role to the interior project.
Well, I'd also say can this also be a finding of fact that the, location, of this use within the historic district of Southport is very similar to other uses, i.e. all houses virtually are close to their neighbors' driveways and accessory.
I wish I had a driveway.
Goes.
All in, yeah, that we can add that. All in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. That motion carries. Motion 4.
Chair,
Yes.
who seconded that?
Rodney.
Thank you, Mr. Ross.
Motion 4.
A motion, the location and character of the use, if developed according to the plan is submitted and approved, will be in harmony with the area in which it's located and in general conformity with the city of Southport comprehensive plan. Findings of fact are that it meets all the requirements of the UDO and the comprehensive plan. And all, period. And then I'll again, basically the same thing I said before for 3, that the, as submitted and approved does not create a situation of more conflict than already exists throughout the historic district.
Okay, discussion of that?
Second to that.
All in favor signify by saying aye.
I,
Opposed, same sign. Motion carried. Motion 5.
I recommend it's not a motion, recommend the approval of the special use application with conditions, including the following, the no rentals, whatever we cover. What stock answer for that.
Yeah, no rentals separate from the primary residence.
And then at the garage, I mean, you can say,
the structure will not be utilized for the storage of a vehicle. And then I'd like to.
Well, let me ask you a question.
Approval of that quote.
It's licensed vehicles. Is that what we're talking about? Licensed vehicles?
No, we're talking about motor vehicles that's defined in.
Okay.
Jar.
Which is any, hang on, it's any conveyance that moves over land or water on this
So,
tower.
back to our lawn home. That would not be allowed to be in that building.
Doesn't make sense. Admit it.
Okay.
By definition, it would be.
Okay, all in favor?
Yeah.
Motion 5. Signify by saying aye.
Well, we need to have the qualification in there. For the commission to be considered.
I don't, the fifth one,
We've always done it after well,
That was part of
the fifth one doesn't have any findings of fact.
Has conditions for saying that.
motions to approve.
and we typically added those after the
Rental and all that.
So, yeah, but Harley, you're right. Is there, we covered the vehicles and the issues that,
So just to recap, there's 2 conditions we're putting on it. No rental of the ADU separate from the main house. No storage of motor vehicles in the accessory structure.
That good? Oh. Okay. All in favor of that, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Yeah, we do second.
Rodney.
Rodney, yeah. The motion carries. So we have made approval of this project and the gentleman who spoke last, hopefully this is done. We can move forward. So thank you. We're gonna take a break, 5-minute break before the next hearing, please.
Thank you, Jacob.
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 Please.
Thank you, Jacob. Thank you. 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 Thank you.
All right, folks, coming back into our meeting here. We're here for the last one is an appeal of an administrative decision by our code enforcement officer. Setting rules apply, as we did earlier. We'd like to ask that the attorneys will come first with their opening statements, and then we'll proceed with the staff reports. Let them make their statements. You want to go first? Or?
I'm going to be very brief. So that's
Yes, thank you, Mr. Chairman. Good evening, members of the board. Brady Herman here on behalf of city staff's position in terms of this notice of violation issued before you all regarding offense encroachment within East Bay Street, on the property owners at 410 East Bay Street, August and Claire Adams. I think the essential facts in this case are not in dispute. There is a fence that is located in front of the appellant's house within East Bay Street. And it's clear that the city's ordinance, both at the time of when the fence was allegedly constructed and today, is a violation of the city's code of ordinances and the Unified Development Ordinance Code, in particular, the general code, section 16-8 and 16-10. I'd like to go ahead and at this time pass out to you all just a brief legal memorandum that you all can read through during the hearing, just to counter some of the arguments and defenses that opposing counsel might be able to have in regard to this issue. I've already given opposing counsel a copy of the legal memorandum. It is outdated in terms of the date, as I had it from last month. But I just want to state for the record, this is my first time giving this to you all in this case.
Yeah.
Just real quickly, again, I want to go over the standard review for you all. So the decision for you all is to decide whether city staff or its decision is issued the notice violation to the appellants. Okay. The notice violation for the appellants, and so you all review that decision anew based on substantial competent evidence that's submitted to you all at this hearing, and we proffer that the evidence and testimony will show appellants are in violation of this ordinance, and that the appropriate remedies are upheld on the basis of city staff decision, in particular, Mr. Derek made with Code Enforcement Alliance. I'll first call Ms. Meehan to provide her staff report and testimony, and then I'll also call Mr. Derek. Thank you.
Good evening. I'm Greg Kiva. I'm an attorney in Oak Island, and I'm here representing the appellants Claire and August Adams regarding the violation order that was issued on September 11th of 2025 regarding the fence at Bay Street. The facts are, as Mr. Herman said, they're pretty straightforward. There's a fence that is alleged to be in a right-of-way on Bay Street, which is incidentally a 100-foot right-of-way as opposed to the standard 60-foot right of way for a street. And if you, the evidence will show you that if you look at where that right of way ends, it ends at their front door. So if they open up the door, they're in the right of way. So they're not, we're not going to make any kind of claim with adverse possession that we own the right of way or that they own the right of way or they own any part of it. But what we do believe the evidence is going to show is that sheer common sense is going to tell you that this fence has been in existence for over 40 years in the same location. It's been there. There's other owners of the property who are here to testify as to where it is. We believe the evidence is going to show you that this fence was in plain view, not obstructed by anything. You can see it from every aspect of Bay Street wherever you are. It doesn't impede foot traffic. It's in fact on the opposite side of the street than the sidewalk of Bay Street. It does not impede the flow of traffic in any way. It does not impede anything that the city intends to do with the property. So what simply may fall as just a fence inside of a right of way is not just determinant of whether or not that fence should be there. Okay? They didn't construct fence. Okay, and we're not claiming adverse possession, but this is not a fence that was put up in a year. Not a fence that was put up within 5 years of the UDO. It was a fence that was put up 40 years ago, or some form of it 40 years ago. And there's nothing that the city or the citizenry of Southport gains by making them take the fence down. The only reason, and the only thing the city gains by making them take the fence down is that it's in the right of way where it's been for 40 years. Doesn't advance any purpose whatsoever, other than. So the presentation that I'm going to have tonight is not going to be extremely detailed in terms of, there's not a lot of pictures. There's not going to be that. What it's going to be is common sense, asking the Board of Adjustment to do just that. Adjust what is there based on the facts. I believe that the facts are going to show, just like what I said, this fence has been in existence for over 40 years. It's caused no problems to the city. There's been no complaints about the fence in the city. The only reason why it's here is because there's a fence alleged in the right. So I'll just reserve time to end closing it for the evidence presented. I believe I would have two possible witnesses. It would be Mr. Adams and Mr. Sidney Ford. Thank you.
Thank you, sir. Mo?
Yes, sir.
Mr. Lehan? And you are who?
I'm Maureen Lehan.
Okay. You swear to tell the truth, no truth, nothing but the truth, so, yeah.
I do. Good evening, Chair, members of the Board of Adjustments. This evening, I'm going to go through some of the basic information about the case itself. Some of it, I don't want to go too far in, but like we've said, it's very basic. The attorneys have covered some of this information already. So this is an appeal to an administrative decision. Mr. Kleva is for the property owners of 410 East Bay Street. They are appealing the final order that is dated September 11th. That was issued by Code Enforcement Officer Derek May for violating both the City Code of Ordinances and the Unified Development Ordinance for encroachment in the right-of-way in the form of a fence. So it's City Ordinance Section 16-8, obstruction of public right-of-ways, and the UDO Section 3.17D, landscaping public property. Both of those mirror each other, basically saying it shall be unlawful for any person to place or cause to be placed on any public street, road, alley, sidewalk, or other public right-of-way within the city, any wall, fence, gate, brick, stone, wood, rock, vegetation, or other structure, material, or substance above the horizontal plane of the existing ground. So just to give you just a basic understanding of what the ordinance, those sections of the ordinance say. This is a survey that was prepared for the property owners in 2024. It's in your packet. I was able to clarify it a little bit better, give you a little more clarity on it. And some photographs that were taken that I was able to take off the Google Street View. It shows the fence in place.
If you will notice the front lot line, like they were saying that the porch almost is on the front lot line there, you'll see. And then the subject fence is out into the right of way just before the first edge of pavement on East Bay Street. And the right of way goes 49 and a half feet to the other side of the pavement on East Bay Street, their property. Some more photo documentation. This documentation was taken in May of 2024 by Derek May, the code enforcement officer. This documentation, again, was made in May of 2024. The violation was sent in 2025, January 2025. There was a delay in the issuance of this notice of violation. At the time, the Board of Aldermen were discussing right-of-way encroachments, right-of-way enforcements, and potential amendments to the ordinances. So we were holding off on this case while the case was open. The notice was not sent. On December 12th of 2024, the Board of Aldermen did approve amendments to section 16-8 and 1610 of the City Code of Ordinances with the directive that all hardened structures must be removed on any existing right-of-way. So this is going to be the obstruction of public right-of-way and existing encroachments in right-of-way where the amendments were and the directive to have all of the hardened structures. Yes.
Would you please define hardened structures?
I don't have a hardened structure per se, but I would say that it would be taken that as the definitions or how it is defined as an encroachment, the instructions themselves in the Code of Ordinances, that includes the walls, fences, gates, bricks, stone, wood, rock, or any structures above the horizontal plane would be considered a hardened structure.
Above the horizontal.
Above the horizontal. The other directive was that any open cases that were existing with right-of-way violations must be enforced. I wanted to just kind of go through the timeline of this case itself. So as I mentioned, the first notice of violation was delivered in January of 2025. Then there was a reinspection that occurred in March of 2025 with no progress. A hearing was set for May of 2025. There was a conflict with the owners, so they were not able to attend that hearing. Then a new hearing was then scheduled in August of 2025 to accommodate the property owners. The hearing was held. There was no, again, there was no removal of the fence. So the final finding of facts and final order was prepared and sent to the property owners on September 11th, 2025, as mentioned previously. So as just a conclusion, the fence is a hardened structure located in the city's right-of-way in violation of the City Code of Ordinances and the City UDO, Unified Development Code. Therefore, we request that you reaffirm the initial and final notice and finding of fact sent on September 11th, 2025, ordering the applicants to remove the fence from the city's right-of-way. And that is the conclusion of my presentation.
Is this based on the 1224 modification to the UDO or whatever it was?
So the UDO and the city ordinances had these clauses that you could not have encroachments in the right of way previous to the December amendments. So this case was open prior to those amendments. It was not noticed until further because of the amendments that were being considered and how the alderman wanted to move forward with enforcement of existing encroachments.
And the storage area has not been determined yet, the overlay, the storage district.
That's correct. There is not an official local historic district. If there is a local district as it is being proposed at this time, if it is adopted, yes, this piece of property will be within the historic district, the local district.
I'm sorry, didn't hear the end.
Yes, in the local historic district. I want to clarify that
It will be, not now, but it will.
right, yes, if
If it's adopted.
if it is adopted,
Yeah.
yes.
When?
No, I vaguely, it's a vague memory. That's, it gets me in trouble a lot. Wasn't it? I thought there was an exception carved out for structures that were this old, 40 years old. Wasn't there an exception?
There are exceptions that were written that include older fences
Right.
prior to 1980, but it also had to be part of, in the historic area it is, had to have a curb and a sidewalk. And then this would be located on the property side of the sidewalk.
But it doesn't have a sidewalk.
Yes.
Yeah. okay.
Yes, correct.
Yeah, okay,
Yes.
okay. Yeah.
As it exists on your side.
Okay, I got you.
Can you describe that stretch where the street flows into the yard there? Is there a curb or any kind of,
There is a curb in that area.
there is?
Yes.
An asphalt, little
Yeah, it's
asphalt.
just an asphalt
Yes,
lip.
it's not a true curb and gutter, but it is, there is a.
That asphalt,
Curb or on the,
yeah.
No, there's not a. Yes, sir.
on this slide, the left side where this survey drawing is,
Yes,
it looks like, excuse me, there's the fence is delineated there. And then
Yes.
there's what is that curving line? Is that
that's
Is that-
existing walkway.
is that walkway?
Yes,
But that's on the right of way.
that is in the right of way.
Is there any request or effort from the city that those be removed?
No,
And that's because they're
they are.
horizontal.
That's correct.
Are they grandfathered in on the sidewalk?
Yes, and you, at this time, you still would be able to we allow property owners to have access to their properties with walkways and driveways through the right of way. So that would not be in violation.
Is that considered a sidewalk then? Is that walkway?
Well, a walkway to your home,
I mean,
access
does
to
that,
your
does that
home.
fall along the lines of what you just?
No, I'm sorry, no, that would not be considered a sidewalk in the definition that I was speaking of. It's-
Is 100-foot right of way unusual in the city?
No, it is very common throughout the city.
How long is this area, this property has been platted?
This is one of the, a portion of one of the 100 first lots,
That,
1792.
that right of way's been there.
That has been designated right away since that time, yes.
99 feet or is it 100? Oh,
I think it
30.
says 99.
Yeah.
Gonna make that work.
That's our favorite.
So in terms of proposed violation, there's only the L section that is considered in violation. That
The fence.
there's two pieces, yeah.
There are, so there's two pieces of fence.
Right.
The fencing that borders the driveway and the portion that is within the front yard.
Right, it's only the front yard portion.
This is for all the fencing in the right of way.
Okay, because I'm looking at the exhibit, and the exhibit says subject fence.
Okay.
And it's, I need to, okay, it points at, if there's two sections of fence that are in violation, to me, I just want to level the floor here. It needs to show both sections of fence. Right now, it only shows one section of fence. And I just want to be clear, we're talking about every piece of fence
That is
within a right. Okay, thank you.
You're welcome.
So following up on that, we're talking about the
Would you,
stuff that runs parallel to East Bay Street and the first section or two of the stuff. that-
Could you point that out with the pointer mode?
It's all in.
Yeah,
Yeah.
I don't know. I don't think the back.
Two sections,
I can't.
two sections are straight and a complete L.
So that, yes.
On the picture. Do it on the picture.
Right, so I'm trying here, okay, I'm sorry. So this would be the section, and without, this is just, I would say these two first sections would be considered within the right of way.
just as.
That's correct. Yes, sir.
So those would be removed.
Yes.
Is there an instrument or avenue. People can request for the city, any kind of permit restrictions like this in the right of way.
Not for a fence, no.
I don't think you can plant tulips.
Unless it's under a tree within a 10-foot diameter of an existing tree.
If previously, prior to this revision, how were the right of ways managed? In that if homeowner had something out there on the right of way, how was that managed?
They were managed.
It wasn't.
There were most that they weren't.
I think, yeah.
But what I can say is I don't know.
Okay.
Previous to my employment, I don't know how they were. I have hearsay of how they were managed. I know that when I started my position with the city, it was very clear that I was to make sure that no new encroachments were made in the right of way.
When was that?
That was in October of 2022.
And about existing.
Did you ever hear?
And there was no directive on existence.
Did you ever hear for consideration? If you have it there, you may leave it there, but if it becomes a situation that we need it, we'll have to take it off.
No one said that to me directly. I heard rumors.
Heard that around?
I heard rumors. But that's again,
That's
hearsay. I don't know if that's the
Well, I
directive.
It has nothing to do with Southport, but that's the way it's managed in many, many towns.
Well, I'll give you my experience. When I moved into town, I wanted to put a driveway out in the right of way. And I was told to go to Wayne Strickland and check with Wayne and say, and he gave me the speech that, hey, it's okay. As long as you understand if the city ever needs it, if they tear it up, you're on you. And,
That's exactly what I meant.
right. And that was, and then
I've never heard it myself. So
They've got
I mean, I
to put it
can't
back
say
to a
what
certain
did or did
Pardon?
not.
They have to put it back to a certain degree.
well, I mean, they would,
Not your improvements.
No,
now,
They have to
I
put
mean,
it
they
back.
dig up my bricks.
They have
If
to.
they dig up my bricks, they're not putting back the
Not
bricks.
the-
not what I put out there.
Yeah.
But, and I guess my question, Harley, in light of the fact that the alderman subsequently changed the ordinance, it's irrelevant what past practice was.
I'm gonna get to another side of it. And that is, why not grandfather for that approach to the situation?
Well, I think they have. I mean, if you
wait, hold on,
read,
that's
what is it, 80 years? Is that the grandfather saying in?
The fence is not considered a net, as I heard, no. Tell us.
No, that's not grandfathered in.
But they grandfathered all those things that were at grade, like the driveway.
They allowed
and things like-
vegetation to remain.
Right,
So any
vegetation and that, but any hard structure above the grade is where they went.
That's correct.
Questions of Mo?
Yes, this is gonna sound a little odd, but I'm just curious. I have a suspicion that there's probably a good number of violations similar to this throughout the city, where we have an existing fence that's in the right of way to some extent. I'm just curious about, for lack of a better word, the priority or attention that's being given to this one relative to perhaps other similar situations throughout the rest of the city.
So in January 2025, once this new ordinance was put into place with the directives, there was a 6-month grace period that was given to anyone that had a hardened structure that was identified by the city that needed to be removed. And then the city staff worked with those property owners to remove them. Once the grace period was up, anyone that had remaining properties, we formally gave them a notice of violation. and went forward with the violations as any normal violation of the code. So currently today we have one left with hardened structure. We were working to get the final.
Correct me if I'm-
That is not included.
So there's two.
So there's two.
And how many did you start with?
There were 88 that we had identified. About an eighth of those were then given some different priorities that weren't required to be removed due to engineering reasons, or we were given some other local policy that we were able to use. So I would say 50-ish, what I would say. Had to have things.
Were any fences or
Yes,
walls
absolutely.
allowed to stay?
Yes, there were some that were allowed to stay, yes.
And what criteria would you?
The criteria was if there was a curb with a sidewalk with a fence that's in the right of way. That was really the fence one. Or any of the walls that you see around the city that are the older stone walls that you see. And then we were also allowed to have retaining walls remain that were holding up earthen structures that were going to be, if we had them removed, it would be detrimental to the property, the city's property, or the street, or any of the utilities that are existing around it. So those were.
Some engineering related
Yes,
structures.
yes.
Can anyone pour a driveway? Right away?
Mhm.
Like go out there and pour a driveway?
You would need to get a right of way from that, but yes,
What's this, the new standards, what, 18 feet,
20.
20? Okay. 20 foot wide.
Yes, we
Driveway,
do allow people to access the property. That we can't stop any.
are you allowed, how many driveways per property?
Sorry, I meant sidewalk. Did I say driveway?
You said driveway.
I apologize. I meant sidewalk. Can it,
Yes, you could get a sidewalk. Same, you would need
so could a sidewalk go between that fence and that curb and call it a day?
I mean, it had to be existing at the time that the
Okay.
ordinance was passed. So.
But did I read somewhere where this thing had a rope fence back in the early, no, before that?
No, I thought it was up the street.
No,
I think Dora said something. When did you buy the
property-
house? 1980, 84?
The original. That isn't that for in there.
Yeah, I read that. I talked about 1980, 84.
Something like that. The original, owner put up he's the one that put up the rope fence, original builder. The house.
That's what we, was that the Spencer family?
Yes, that is what the information that we're.
I mean, I thought that's the information I read that.
But that house was built in 1996. And when was it?
97.
Okay.
That doesn't sound right.
No.
It's not.
Let's go back to Dora's. Dora's affidavit.
Yeah.
Yeah, that was earlier.
She purchased it in 97.
Doors.
Probably about 80.
Somebody looked that up.
Probably about 85, I would think.
Spencer bought it December 4th, 1980.
Yes.
I believe it was a vacant lot
Lot.
at the time.
And
Least it's not
notification of, the situation. Was it ever stated by the city what that was standing in the way of? Why would I have to do it now? Was that ever looked at?
It was at the time, the city was trying to get all of the right of ways open without hardened structures above the horizontal. That was the
But
initiative.
any I needed for this.
No, sir.
And I think that's where this committee deals with, the variance and other big problems.
Do you have another follow-up, Jason?
So I just want to be clear, at least as late as 1980, this was still vacant lot, a bare lot, or didn't have anything on it, and the house came in sometime in the early 80s. Is that right?
I would.
I believe that's when Mr. Spencer bought
It
that.
was finished in 81.
Thank you.
80.
We bought it December 4th of 80, so they couldn't build a house.
It says the road fence was installed by the Spencers at the time they constructed the residence upon this.
They had a fence line with that.
And it remained in use until
Post
97.
and rope. Whether
Doesn't matter.
if it's wood or rope and post.
Any more questions?
I'm sure you'll be back.
I think it's starting my case here, but yeah.
Good.
Cut it in half.
Last week.
Wait, are you are you getting up to,
I was gonna give her my seat, that way she didn't have to check out too much.
Mr. Herman, I guess, is your.
May I proceed?
Please.
For housekeeping, I'll go ahead and enter in city staff report and city's exhibits A through J to the right. And I'll just be referring to the staff report, or excuse me, the agenda pages, so everybody's clear on what page I'm going to. First, Ms. Meehan, are you responsible for adopting city ordinances?
No.
So your job is not to go and create a policy, is that right?
That's correct.
And whose responsibility is that?
For this instance, it was the Board of Aldermen.
The Board of Aldermen makes those decisions for UDO and general, is that right?
Yes.
So your job is to go and enforce the UDO as well as Mr. May in terms of the general code. Take me at this survey right here, and that says Exhibit B into the agenda on page, looks like it's on page 60. Page 7.
Yes.
Is that a recorded survey plaque,
Reported. No,
like in the public registry?
no,
So how did the city go and obtain that?
that was part of a building permit.
Okay, okay, so
What
that's,
page you on?
it's in the city record.
That's, yes. it's-
Okay.
Yes.
Take me through, so in May of 2024, code enforcement officer, Mr. May opened the case, is that right?
Yes.
And at that time, what was the city's ordinance in terms of fence encroachments within the road?
It was, as considered earlier,
So if you go to
yes, I apologize.
exhibit D1, page
D1,
75.
yes, that's the exact.
Okay, and so fences in the right of way are not permissible according to section 16-8, subsection A.
Correct.
Okay, and if you look on exhibit D1, it has parentheses at the bottom. Is that right?
Yes,
And what does that tell us?
That tells us when the ordinances were originally adopted and also when they were amendments were made to those.
So according to this, it says code 1974. Is that right?
Yes,
So that means that this ordinance has been in effect since 1974.
yes.
Well prior to the alleged, or well prior to the time when the first owner purchased the lot and built and constructed a house on there, presumably any fence.
What was the date on that?
1974.
Okay, the UDO's first.
And if you flip over to page 77, this is also codified in the UDO, is that right?
Yes,
At least at the time of May of 2024, it was also UDO.
yes.
And if you keep flipping over on exhibit D3, what does this mean?
That is a copy of the, or a portion of the Unified Development Ordinance that was adopted in 2000.
Okay, and is this as far back as the city records have in terms of previous UDOs?
Not as far back, but that we can find with this.
Okay, I got you. And again, it goes through sort of the existing encroachments on right of ways. It recodifies essentially what's in the section 16-8.
Yes.
So we have May 2024, Mr. May goes and opens up the case. So it's an open case. Was this the only right of way encroachment
open case at that time, May 2024?
There was one of them.
Okay, so there was two at that time. Now, Mr. May, it took him, several months after that to go and issue the first notice of violation. Is there a reason why a notice of violation just wasn't issued right there, 2 days later to the property owners?
Yes, there were conversations with the Board of Aldermen at the time about encroachments, existing encroachments in the right of way, and how they may or may not be enforcing. So we were kind of saying it so that to see how they may fall on the decision.
Right. So during that time, I mean, how many public hearings and meetings and discussions did the aldermen, who again are the policy creators, how long did that go and take for them to actually go and make a decision?
Months.
Okay. And so at that time, presumably, whether it was staff or the manager told Mr. May to hold on enforcement until a decision was made by the aldermen what they're going to go and do in terms of updating or not updating. Okay. So take me through December of 2024, looking at Exhibit I there. So that was the ordinance that was adopted in December 2024 by the, right?
That's correct.
Can you walk us through, because there's a lot of discussion about exceptions.
Okay.
Okay. So we'll let me back up. First, are the appellants in violation of the newly adopted ordinance in December 20?
Yes.
Okay. Specifically, section 16-8, yep, and 16-10, is that right?
Yes.
Okay. So walk me through, I guess, the proposed changes that are relevant to this case. And I think it's important that we go over the exceptions that were, again, decided by the alderman at that time, what and what was not.
What clarifications did you want me to speak to the changes that were made or very specific?
What are relevant? I'm not trying to take too much time. I think it's important that we use this language in here to go over what exceptions that was loosely talked about. Okay.
So what page you looking from?
Yeah, so, excuse me, I'm sorry, on page 87. 87 through 89, city's exhibit.
Yes. So Exhibit I, if you look at 16-8B, that is where we're speaking about the 2 parking spaces of 20 feet total width. And that would be where the driveway would come in on that. It also outlined what types of paving would be allowed. The UDO administrator could waive requirements for wood border if necessary. Really, for this property itself, that nothing else in this section. Then we would talk about.
Looks like the exceptions might be.
Yeah, it's gonna be, yes, it's gonna be for the existing encroachments, really, for 16-10, B, so that vegetative encroachments.
Right, on page 89.
On page 89,
Yep.
correct. That's where it outlines that you are able to keep existing, any vegetation that was existing prior to the adoption of this ordinance in December of 2024. They're permitted to be expanded as long as, and then the city has the right to remove them if necessary. Also, you're allowed to install native trees when a city tree must be removed for construction, or if there is a diseased or dying tree that you want to replace in front of your home. Then this next one is where the curb and public sidewalk exists. Private fences, walls, and vegetation installed up to the private property side of the sidewalk existing at the time of the adoption of this ordinance may remain. All approvals and building permits must be obtained for maintenance or replacement.
So just stopping right there, that's a grandfather and then provision right
That's
there,
correct.
that's correct?
Yes.
Does subsection C apply to the appellants in this case, according to how that ordinance is
You're
reviewed?
just.
Okay, and continue on to subsection D.
The next one is any fence or wall located in the right of way in the designated National Historic Register or in a local district built on or before December 31st, 1980, may remain after written determination by the UDO administrator or the Historic Preservation Commission that the structure contributes to the historic.
And does that exception apply in this case?
No.
continue going to page 91, exhibit J, is this the minutes from the Board of Aldermen meeting where the Aldermen adopted that ordinance?
Yes.
Exhibit I. And if you turn all the way to page 93, can you summarize what Alderman Mosteller's motion was in terms of approving and what, I guess, add-on she had in terms of open enforcement cases at the time?
Yes, so her motion was to adopt the ordinance as we just reviewed that was adopted, but also saying that there was a 6 months grace period for enforcement for those existing to allow us to work with the property owners adjacent to these. And then it does mention that any active code enforcement cases prior to the adoption of this ordinance shall remain in place. So we must move forward with their enforcement.
And that includes the Pellets. Is that correct?
Yes.
And there was one other property that was an open enforcement case, and that was also on East Bay Street. Is that right?
Correct.
So according to the direction, again, of the Alderman for staff, was there's no grace period for open enforcement cases, right?
Yes.
Which is why the code enforcement officer, Mr. May, and his staff sent the notice of violation.
That's correct.
I'll go through the timeline. Go back to the discussion which was the question that I was really wanting to go and get to, but just a little bit more clarity. You know, we have January, we got to go and tell all these property owners they're in violation. So roughly how many were in violation of right of way?
88.
88. And I guess as of today, how many of those have come into compliance?
All but one.
And to your knowledge, are there other property owners in the exact same situation as the appellants? Maybe not necessarily the same street, but that had a fence that is in front of their property, not within their property line, but within the right of way that had to go and remove their fence?
Yes.
And did they go and comply?
Yes.
And you said there's just one outstanding as of now.
Yes.
Okay. You know, I think it was discussed briefly, but this term grandfathered in is another word for that, sort of a non-conforming use.
Yes.
And can you explain to the board why this could not be considered a non-conforming use? I could think of several reasons, just a generalized sort of, in your expertise of why this would not be non-conforming.
And non-conforming structure has to be legally established, able to be legally established at the time of the change of.
And this has always been.
That's correct.
Is that right? And another contention or allegation raised by the appellants is that they didn't go and put up this fence. So whether it's a general code violation or a zoning violation, if I create a illegal use on my property and I sell that property to somebody else and they continue that illegal use or the illegal violation, does that absolve the subsequent property owner in terms of being allowed to continue the violation or not?
No.
So in other words, they would have to, as long as they were cited, just because the first person wasn't cited, the second one, just because they continue the violation, they would still be in violation of the general code or the unit. Is that right?
Yeah.
Okay, I think that's all I have.
I just have a few questions, just touching on what you said, that was raised that there were other property owners that were in violation of the UDO when this enforcement came down. I personally don't think that that's relevant to this property, but did any of the other property owners, to your knowledge, appeal any of the orders?
There was one. Well, not in the sense of those that were notified after the adoption of the ordinance? No, there were not.
Would be fair to say then that those people made an internal determination that they would remove it as opposed to trying to bring up an issue and enforce, or bring up an issue to enforce a right that they thought that they would have not to move. And there's been a lot of testimony about when the UDO was in effect, and I believe you said, in answer to Mr. Herman's question, that there was, that they have quote, always been in violation of the ordinance. Is that fair to say? Right. So can you tell me as a staff member, could you tell me if there was ever any violations of any of the ordinances from 1974 up till this ordinance for that property, for that fence?
No.
There was also some testimony that, you know, that the appellants they certainly didn't build the fence. But I don't believe that we're saying there's any assertion that it doesn't apply to them, that it's there, or absolve them, but would you say that there are, or there could be factors unique to each property owner that determines whether or not a certain fact or outcome should apply to them? Meaning every case is not the same.
It is not the same, but at the same time, we do have ordinances that I have to consistently enforce.
And you came in 2022, and you testified that your main job was to make sure that no new encroachments went into the right of way, correct? Would you characterize the fence there as an existing encroachment or a new encroachment? So no new encroachment came in from when you were at least there?
That I'm aware of.
Okay. And then from 2022, when you were there up to now, there was no other complaint or violation issued by the city for that existing structure, correct? And it is fair to say that you don't know, or you can't testify as to how the city managed encroachments in the right of way in the past prior to that other ordinance? Would you characterize the enforcement of the UDO in this way as a blanket enforcement?
Again, I consistently enforce the ordinance.
So from when the ordinance was amended and the alderman said you have to remove things in the right of way, that was just go remove things in the right of way?
That was our directive, yes.
Okay, now I'm
And that's when we started to be proactive in our enforcement of the right.
Okay, and was there any time from when you were being proactive in the enforcement of the right of way that there was any effort to work with any of the 80 property owners to try to offer some type of alternative outcome other than just strict removal? It was either remove it or not?
There were some policies, local policies that were made but we did try to work with everyone as possible, but at the end, if it was a fence, hard structure ends, they needed to remove it.
Okay. And you had also testified that the survey that you showed was not a recorded plat survey.
Yes,
So that's not a recorded survey in the registry or anything like that.
that's good.
So there's no evidence here really as to where exactly the right of way is from a survey perspective. It's just what was in the building permit.
May I make a point of clarification on that? That's a signed and sealed document.
Right, okay, I'm just asking, it wasn't recorded, that's all.
It's not recorded.
Okay.
Yes.
In the public record.
It is in public record.
Thank you.
I just got one follow-up question that pertains to that. So Exhibit B, I mean, this was a survey for the appellant, is it not?
No.
I mean, I'm looking, well,
I'm just asking for the record.
yeah, fair.
That's it. I didn't understand that.
But yeah, but I just want to be clear that this is a survey that shows the fence, shows the property line, shows the, so I do think, would you say it's clear that the fence is in violation?
Yes.
One of the districts followed to that sort of, when that survey, do you know when that survey was put on record? For the appellants?
I believe it was in 2024 for some renovations.
Okay, and did a permit get issued for the renovations, do you know?
Yes.
Okay, did city take any objection at that point to the survey that they had in their possession that they were potential violation of the fence?
No.
Thank you.
I would next like to call Mr. Derek May.
You swear that that's a good vote to the good stuff you got?
Yes, sir.
Mr. May, would you go and just tell the board what you're doing for the city?
Yeah, I am one of 3 code enforcement officers for the city. My job is to enforce the code ordinance and to find any violations, I'm going to enforce that by organization. Contact with the property owner.
And Mr. May, is it just you that works for, again, what's your company's name again?
Alliance Code.
Yeah, is it just you that works for them in terms of personnel from your company in the city? Or is there other staff involved?
There's one other staff member. His name is Logan Boaz. He's here today. So he is, he works for my company. And then the city has one other staff member that works for them directly.
Okay. Will you take me through when you first became aware of the violation at issue?
Yes, doing, our routine, violation checks, checking out the city, going through the city. And I believe it was also brought to my attention by a staff member, but I can't recall, who made that was the check, violations, happened on, May 1st, 2024. That's when I first documented the case, noticing that the offense was in the right of way. There was also one neighboring property that was there too as well that had the same violations, and both were documented.
And in looking at the staff report, page 65, it's not these pictures right here. Otherwise, that'd be really easy. But I guess you have that. Yeah. Did you take those photographs?
I did.
And what do these photographs show? Or excuse me, what property does this pertain to?
This one is 410 East Bay Street.
Okay. And are these fair and accurate representations of events that are of the day that you took these pictures and fence encroachment?
Yes.
Okay. And take me through, so I guess what happened after you went and took these pictures? According to the staff report, you opened up the code enforcement case. Is that right?
Yes, I opened up a case, and what I do is I document in our log that also is available to all staff, certain staff members with the city. What we do is we take photographs, we open a case log that documents exactly what we found. We also any documents that we plan on mailing to the property owners, they'll all be documented as well, and we give the case number.
Okay. And obviously you didn't go and issue notice of violation right away, right?
Not right away.
And why was that?
Just by directive of staff to hold off on all encroachments of the right of way at the time until a final decision is made.
And that was not just them, but the other code enforcement case that was.
Yes.
Okay. Okay. So the months go by to wait and see what the aldermen are going to do in terms of updating the right of way ordinance. They get adopted in December of 2024. As Ms. Meehan testified, there's a motion that says all code enforcement cases will go and continue in terms of enforcement. So given that, what happened next?
The next thing was we looked at the cases that were there and we issued the notice of violation.
So in looking at page 81 of the agenda packet, specifically City Exhibit E, we just identified that.
So this is the courtesy letter / first notice of violation.
And that was sent on which date?
January 13th, 25.
Okay, and can you just summarize the contents of what it has in there?
Yeah, so, basically, if you look, it'll say zoning violation, existing encroachments on right of way violation. And then it will say, the next, statement will be right of way violation, white fence, identifying the fence was installed within the right of way. We also gave a 15, there's typically a 14 day, but we always give one extra day for mail time, within the city. So we gave a 15 day to correct the violations. Go down further, you'll see it's to correct the violation, what they must do, remove the white fence from the front of the property as it is not permitted to be installed within the city right of way.
Okay, and, in there it cites a provision which is the general code, is that right?
Yes, also directed to chapter 16-10.
16-10. So we're relying on the general code provision that was updated, right?
Correct.
That also existed at the time that you were in the
Yes, it is.
Okay, so under either of those, they were in violation.
Correct.
Okay. All right, so what happened after the 15 days?
So after the 15 days, what we normally do is we try to give a little bit of leeway. We don't always just try to hit the hammer and say, hey, let's, we're going to instantly just do this. We try to give a little bit more time as a courtesy. So we actually gave an actual courtesy that we didn't have to give. When it comes to zoning violations, technically, their notice of violation is one of the things that we did. That's all we really needed to do. But we went a step further. We actually sent out a notice of hearing. That way we can get the property owner into the building, have a conversation with them, let them know what's going on, and try to come up with a timeline that would benefit everybody. So we actually sent that out. Let's see.
Is that Exhibit F, page 82?
Yes. Yes, that's gonna,
Right?
yeah, I do. So that went out May 22nd, 2025.
Okay, and that got sent to the appellants,
Yes,
and that was to go and schedule a hearing, then, was that right?
yes.
Okay, and it said the hearing would be held on June 5th, did it take place on that day?
The hearing held place, but the property owners were not there.
Okay. So then explain Exhibit G for me. Were they not there, or did they get rescheduled?
They got rescheduled. They had called after the fact and mentioned that that they missed the hearing due to a vacation being out of town. So what we did was, as a courtesy, we rescheduled for another hearing.
Okay. So talk to me about Exhibit G, page 850.
So this is going to be the rescheduling hearing where we went and try to get them to come in again. That was sent out July 18th, 25.
Okay, and the hearing would take place when?
August 21st, 25, 11 a.m.
Okay, so flip to page 84 for me. And tell the board what happened at the hearing day on August 21st, 2025.
So the property owners did not show up for that hearing.
Okay. And what does this, and was there any indication by whether it's the council or the appellants of, them coming to the hearing today?
No, I never heard anything about any reason as to why they didn't show up in that second.
Okay. And what happened? Was it just staff that showed up on August 21st, 2025?
Yes, it was just actually.
Okay. And just take us through this finding of fact and final order Exhibit H. What is this all setting for? And what is the result?
So I do remember, this, like I said, this is something that we don't technically have to do, but we did as a courtesy. We sent out a finding of facts, letting them know, hey, we've been through this entire process, and it'll show on number 7 there, the right-of-way encroachment violation, white fence has been installed within the right-of-way. Again, on number 9, it's going to show the zoning violation, existing encroachment in the right-of-way violation, chapter 16-10, just reiterating what's already been in the past. On number 11, if you look, this case was open on May 2nd, 2024. Notice of violation was sent January 13, 25. Hearing were held June 5th, 25 and August 21, 25. The property owner did not appear. The property remains in violation.
Okay, and did you give them a timeline for compliance?
We gave them 15 more days with this, finding fact.
Okay, which would say September 26, 2025, right?
Yes.
And then, obviously it didn't happen, immediately thereafter, but it was a sort of a waiting period, it sort of stayed to give them the opportunity to go appeal it to this body for just 30 days and then president council submitted that time. Is that right?
Yes.
I think that's all the questions I have right now.
Thanks, sir. Just a couple of questions. You were reciting the findings of fact that you had made in that order, and you mentioned number 7 and number 9. At number 8 there, it says, based on the evidence presented, the inspector finds that the structure is an imminent danger to life or other property. So based on your inspection of the property and issuance of the violation, your report is saying that the fence that we saw in the picture is an imminent threat to life or property. Is that fair to say? No, it's not a danger to property. This could be possibly a type. Okay, so so it's not an imminent threat. No. Okay, so that part of the report not correct. Did you also in the report indicate that the fence was deteriorated and dilapidated? No, I did not. Just for my knowledge, then, you go to number 11 on, I believe it's the second page of the report, where it says minimum housing. Yes. It says, based on the findings of fact, I determined that the structure can be repaired, altered, or improved to comply with the city requirements of all building codes, applicable requirements of North Carolina State Building Code for less than 50% of the value. And then so the structure is therefore declared deteriorated or dilapidated. Is that not a finding of fact? No. What is that? If it's in the report and not marked out, what is that? It is marked out. So everything under the minimum housing section for deteriorated structure or dilapidated structure is completely marked out. Why is it marked out then on line 2 where it says cannot? Why is cannot marked out? These are generic documents, and we go in and change the certain things. Okay, but do you review it before you sign it or before you submit it? Yes, we do. Okay, so the report has some errors in it. No, the report only had the one error. Okay. All right. When you did the inspection of and saw that the fence was, supposedly in the right of way, is that the only sort of investigation that you did? Just looked at the fence and said it was in the right of way? You checked the map system that we typically use. Which was what? Land lot. Did you look at any of the surveys that were on public record in the Kent with the city? I did not look at the survey. Do you know when the fence was installed in the right of way? I do not. So you wouldn't know who installed the fence? I don't know. Thank you.
That's all I have.
Yeah. That's all, Mr. Adams.
August Adams, 410.
Raise your right hand, please. Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Thank you.
Thank you, sir.
Mr. Adams, can you just tell the board when did you purchase that property?
I purchased 21, I think. 2021. No, 2020.
October 2021.
I was talking about, when you purchased the property, was that fence existing there or did you construct the fence?
It was.
Okay. Do you have any knowledge regarding the fence and whether or not it was there before you purchased it or how long it was there?
Well, you can look at the satellite views and you can see it all the way back to like the mid 80s. At that point, it becomes too green to make out anything. It's been there at least since.
during the time that you owned the property, did you hear from the, other than this instance that we're here from in this appeal, did you hear from the city at all regarding the fence at all?
I did, got initial letter in January of 25.
Right, no, I'm talking about, so this,
Oh, no,
other
no.
than this violation that
No.
we're talking about, which was
This was-
notice of the violation in 24 and early 25, other than that, did you?
No.
No. Now, there was some testimony about, the notices of hearing and things and not being present, so I just want to kind of clarify some of that. So the first notice of hearing that was given was for a June hearing, and I believe they said you were away on vacation.
It arrived the day after we left and it was still before we got back. So
So
I
after that,
discovered it when I came home and
so after that, there were some efforts made to reschedule the hearing, right?
yeah, so when I applied for a variance, because I thought, well, that's probably the proper way to do it. So the city took my money and we scheduled a variance here.
Okay, and just stop right there. With respect to that, while that was going on, was there any information given to you as to what to do kind of in terms of the hearing that was for this violation?
Well, I think there was some misunderstanding. So we had the variance hearing scheduled around the same time as this hearing was scheduled. So I went in the city office, I talked to Mo, and I say, hey, you know, what can we do with this? And she offered to postpone the hearing, which was for the variance or the variance hearing. I understood to mean this hearing, and I thought it'd been pushed back to September, and I got discovered obviously, so later.
So would it be
And
fair,
then, yeah,
would it be fair to say that you didn't ignore the hearing?
I didn't ignore it.
You had every intention to go?
I did. Yeah, my understanding was it had been postponed. I didn't realize that there were two different hearings. I thought it was all the same.
Do you know who Dora Laughlin is?
Yes,
Who is that?
that is Doris from our home.
Do you know where she lives now?
She is in, I believe, Carolina Beach.
Did Ms. Laughlin ever give you any information about the fence?
She did. She said, she had told us that she had been allowed to keep it. She had actually went to the city and was told she could keep it.
You don't know who she talked to or any of that? Other than getting the violation and being requested to move the fence or remove the fence, was there any other discussion of any other possible option regarding the fence?
No, when I actually asked about that, Wendell maybe I emailed, I said, well, what's our options here? You know, what's the next step? I was told the next step was that.
So it was just remove it or nothing?
Yeah. And, you know, initially when that big 88 letter thing went out and people could approach the city to come up with some kind of understanding, we were never allowed to be part of that because we had this open violation that we were never informed of until after those letters.
Let me ask you some things about the fence, but is the fence obstructed by anything? Like, can you see it plainly from the street?
Yeah, I've seen it.
So it doesn't block traffic, doesn't block like foot traffic or roadway traffic?
No.
And we saw from the picture, the right of way as it stands now goes right up to your front door. Is that correct? To the porch area, but it's right. You ever receive any complaints from any adjoining property owners about the fence?
No.
Anything from the city at all about the fence other than what we're here for tonight?
No.
Did you ever replace the fence?
No.
Yeah, I really only have basically one or two questions. Mr. Adams, I'm just gonna hand you up real quick, this exhibit B. You just identify that for me. Tell me what it is.
Yes, it's a survey of our property.
Okay, and did you get the survey prepared. Okay. And just to go and be clear, that survey shows your property line. It shows the city's right of way and it shows where the fence is located. And where's the fence located? Is that in, within the right of way or is that on the property line?
It's not marked.
If it's helpful, I'll just go and hand out. Also referencing page 61.
Right, I understand it's each front line, but it doesn't say what's in front of us. It doesn't say right.
If it here's, well, it says fence right here.
Yeah. Yeah,
Right.
I'm just saying, it doesn't say right away.
Well, it says East Bay Street. So are you disputing that the fence is not within the right of way?
No, but you're asking what the show and it doesn't say.
Okay, so that's not disputed. It's a simple yes or no. You don't know if the fence is within the right of way?
I shouldn't have this, but. No.
Well,
Keep saying on that show.
Well, you had a survey prepared, sir.
But it doesn't say right away.
Yeah.
It does.
Yeah, under East Bay Street, right away.
Let me see. Maybe I'm just missing it.
East Bay Street, right away.
You can't read it. Okay. Just can't read it.
It's there. I'm good.
Oh, yeah.
Is it one of the witness? Mr. Sidney Fortney?
Your name, please, sir?
Sidney Fortney. I'm 413 East Bay Street, across the street from this property. And I own the adjoining property, the lot you saw. You fence is running.
Okay, you can swear to tell the truth, the whole truth, and but the true self you got?
We bought our property in 87. And I think it's been pretty well documented. The fence has been there all that time. I can speak pretty well for that neighborhood. No one on that neighborhood is bothered by that fence. As a matter of fact, I love the fence that runs down the side there. And it keeps the football and everything in when you're out there passing the ball. It's just a nice fence. Donald Trump would say the big, beautiful fence. And it's got, they had it decorated very well at Christmas stuff. Wreaths and everything. And just from living there all that time, we moved there, the crab factory was there. As far as these right of ways are concerned, they've always been there. The property that I own had a driveway through it that went into Laughlin's house before we bought the property from Laughlin. No one, all we did about the right of way, I guess we knew it was there, but we took care of it. My lot, I've got the watering system, sod in the right of way. I don't know what's beside that.
I just want to get a few questions, then I just did. Just a few questions, Mr. Fortney was just, you had said you lived at that property for a very long time,
Yeah.
right? And have you always been able to see the fence from your property?
Yeah.
Right, and has it been there, or a form of that fence been there for your entire time that you own that property?
Yes.
And you say that it's been there for at least 30 years?
Yes.
Okay. And it's not obstructed by view, it doesn't block the roadway, and it doesn't block any pedestrian traffic. That's all the questions that I have for Mr. Fortney.
Thanks, sir.
Any questions? Do we have any questions by staff?
Yeah,
To these gentlemen or just a discussion later
on
on?
the inspector. In the letter that was written back dated September 11th, 2025. Number 8, page 84. Number 8 reads, based on the evidence presented, the inspector finds the structure is an imminent danger to life and other property. Could you explain that? Give me some facts behind that.
We just went over that.
It was a mistake. I'm sorry, John, if it's offended you, but I need to come to the camp like you. All right, let's keep it directed, please. Harlan.
Yeah, when this document was prepared, the wrong thing was marked.
Okay.
Mr. Chairman?
Yes.
One more question.
Please. Was there any concern when you went out for your inspection to assess the condition of there? Was there any concern about which one to call them, mini boulders along the edge of the right of way, or along the edge of the pavement, sorry?
Right. Boulders wasn't one of the things that was mentioned at the time when I opened this case, but technically they would be a violation as well.
Wanted to see if that, I know it came up on a prior case along the same stretch of right of way. Just wanted to mention. Thank you.
I have a question. Did you observe anything that you felt was a citable violation within the vegetation?
When it was had vegetation growing over on the fence, but that wasn't the priority at the time.
Landscaping.
Yeah, I mean, some trees could be cut back, you know, a lot of times in code enforcement, we try to establish a communication base first. So even if there's like tons of violations on the property, what we'd like to do is get in contact with them, establish a rapport with them and be like, look, I just want you to know you also have this. If you know, it's an easier way than coming after somebody saying you got this, and this. You know, if we can make communication, it just makes everything much smoother. And that's how we try to approach it most of the time.
Did you observe the retaining wall that extends into the right of way?
Those pictures again.
It's marked on the survey.
Eastern wall. That would fall underneath the grandfather part of his holding.
It's also an engineered.
That against it.
Retaining wall. There's one note that the issue at all. Do you have exhibit B?
Page 70.
That driveway drops below grade. So
I didn't observe the right of way. I mean, the retaining wall as being a violation at the time.
But you did see.
I'm sure I've seen it. I just can't recall.
Would that normally be something that you cited?
It depends on the elevation. Yeah, if it was a retaining wall that's engineered or something like that, I wouldn't typically go after something like that. That's actually holding
from
up
the survey or from the picture that's on page 65, enough information to see if that's a problem.
That shouldn't be a problem. That is, it's a holding up the dirt. You know, it's designed to hold back. And when it was, whoever graded it, actually probably, I'm sure, needed that in there. That wouldn't be considered a violation.
Thank you.
Questions? Questions anymore? Each of you?
So I think we have to do
Just brief one.
Yeah.
Again, thank you, board, for hearing us tonight. Like I said, this is what I would characterize as common sense equity matter. it's clear that boiling it down to everything, we have the right of way, the fence is in there. Okay, we're not here to rewrite that or determine, that there's no right of way, violation. It's in there. Okay, the facts are what they are. But it's not a blanket case. It just doesn't mean that because it's in there, it needs to move. This fence has been there for 40 years. 40 years. They didn't install it. They didn't install it 10 years ago. They didn't install it 5 years ago. And you heard testimony, even from the staff, that it's been in violation for 40 years, but there's been no action taken. None. Whether or not that wasn't the practice then, and that's the practice now. Well, that has an effect because nothing was done for 40 years. And now these people who have been owning the property for the last 6 are now saddled with oh, by the way, your only options are move the fence. And a lot of discussion about developing rapport and helping the citizenry, but at the end of it, it's either move the fence or get it, or we're here. So that doesn't sound to me like there's any kind of effort to resolve the matter. Okay? There is no claim here, and there won't be a claim because there can't be, of adverse possession. Different, if this was a city park and the fence was up there for 40 years, I would file a lawsuit for adverse possession. So we own that now, but we can't, the right of way. But we're not saying that we own the right of way. All we're saying is that it's been there, open, obvious, doesn't obstruct anything, doesn't cause a danger to the citizenry, doesn't cause a danger to or objection to neighboring properties, doesn't accomplish anything by removing it, except for removing it. There's no issue with if the city needs that property because they want to pave the road and widen the road, the fence comes up, no issue. I would propose that because it hasn't been, no action's been taken for that long, that the violation should be dismissed. But alternatively, I would propose that there be some kind of effort made to accommodate the people who own the property and have had that fence there for that long. I would propose that if the board is not going to dismiss the violation, that it consider an alternative and allow that fence to remain there. And if the fence gets destroyed, if it gets knocked down in the storm, if it needs to be, repaired and it has the value of that fence and have to repair it more than 50% of the value, then you can't put it back up. But why make them take down a fence that's not dilapidated, not abandoned? It's just there and it's been there for 40 years. Again, I would ask the Board of Adjustment to adjust it to having the fence there until such times it needs to be moved. What's the harm to the city and what's the harm to the citizenry by making them do that? I don't see any, so that's what I would ask you to do. Thank you.
I know we're getting past hour number 3, so I'll make my spiel very brief. If y'all wouldn't mind just taking out my memo, I'm going to sort of just cipher 3 main arguments. The first being, I think, which is one of the most important, is previous non-enforcement. I want to pay attention to you all. So one of the leading cases in North Carolina, City of Raleigh v. Fisher, was held and other courts have held after this one, that prior failure to enforce any sort of municipal ordinance does not include future enforcement. Of what happened in that case, the facts were that city staff knew about an illegal violation, advised the defendant that it couldn't be done, and took no action to stop the unlawful use for over a decade. What the court said is that a municipality cannot be stopped to enforce an ordinance against a violator by the conduct of its officials encouraging or permitting such violator to violate such an ordinance. I mean, that's, besides the decade and this being, 40 years of what the opposing counsel and the appellants are saying, it's the exact same situation. There was obviously a period of some sort of non-enforcement by the city. This ordinance has been in effect since at least the mid-1970s. But just because we didn't go and enforce it in the past does not preclude enforcement in this case. Opposing counsel has already sort of agreed, according to the statute that I've attached to my legal memorandum, GS 1-45, there's no such thing as adverse possession or prescriptive easement or any sort of property rights to be able to for one to go and obtain in terms of an encroachment into any sort of public right of way or alley. And so otherwise, no statute of limitations in terms of remedy enforcement. And then again, I'll just reiterate, kind of moving towards page 3, the sort of grandfathered in. Yeah, it's a little bit more, I think, of a practical, I got the term to use, equitable solution that they're proffering. Again, there can't be any sort of grandfathering in as the code of ordinances has been in effect before the those listed. Can't go and have any sort of restrictive adverse possession in terms of the 20 years. And I think just a general premise is, a sort of violation runs with the property and not to be an that's just generally principle, land use principles and ordinances, which you heard from Ms. Meehan explaining that, that doesn't, absolve or preclude, a property owner who has an existing violation, even though they weren't the ones to go and issue. I will just say real quick, the equitable argument, I think, it is what it is. It's a fair one. That's one I would make if I was on the appellant side. But I also want to keep in mind in this board the equitable in terms of what about all the other property owners that went and got issued a notice of violation shortly thereafter from the alderman, said, okay, remove your stuff by mid-June, or else we're going to go and proceed with enforcement. And all of those property owners that removed their fence or remove their shrubs or whatever that was in violation. Just want to keep that purview in mind here as if we're going to go and be consistent, which is what staff is directed to go and do upon the Board of Aldermen's decision in December 2024, that you all should look at it from, again, stepping in the shoes of staff, whether this was done correctly in terms of the facts in this case and mistakes. And I think all the evidence and testimony, we have the survey, fences in within the right of way, and the ordinance says that is not allowed. This is not making those exceptions. So we ask that you affirm city staff's decision in issuing the notice of violation. And if you do affirm, give direction of what the timetable remedies are in terms of compliance. Thank you.
Thank you. Does staff have any questions of the staff or the attorneys or anybody good? Did anybody to speak, sign up to speak that hasn't spoken? Yeah. Just call the question. Yeah, close the public hearing and call the question.
I make a motion to affirm and uphold city staff's decision to issue a notice of violation subject to the appeal and order of subject to this appeal and order the appellants to remove said fence encroachment within 15 days.
Second. All in favor signify by saying aye.
Any you're gonna have some conversation.
Yes, you will.
Second.
Yeah. Second.
We had a second. So
Discussion.
I got him to say.
All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Motion 2. Oh, okay, that's right enough. Yeah, I got it. It's been 3 hours.
Days, right, and you've got 15 days, I don't think it's going to be quite a lot. Just to clarify, Ray, with the 15 days, we're asking for clarification of that. 15 days, effective running after the 30-day period for the deal, if they decide to do that. There's one thing. I'm not suggesting they will. Yeah, just to be clear about when your 15 days.
I think the 15 days starts when the order is signed. Yeah, and then from there, what I think we typically do in the past is let the 30-day time period run out because you can't genie back in bottle.
We gotta get the order time. And 15 days, well. You get 30 days past the 15 days, it's the current 30 days, that was done.
Okay, and I'll draft the order, I'll circulate it to Ray and Greg, and then and you can. There's some what he said.
All right, so we, what other business do we have? Huh? Yeah.
Hey, I didn't make a motion. Calm down.
We adjourn.
Second, I gotta go second. All in favor, say aye. Thanks.